Hi, Phil Silverman with the Silverman Law Firm here today, and we are going over the process to release a judgment lien against the homestead property. So let's put this into context. Our law firm traditionally gets a lot of calls. Most of the time, they're credit card judgments, but they could be any kind of judgment. So someone gets a judgment against them because they didn't pay a credit card, or it was some kind of business dispute, or whoever, why ever loses a lawsuit, gets the judgment, and then what the creditor does, that's the person who was the recipient of the judgment, who the court ruled in favor for. The creditor then files what's known as an abstract of judgment in the real property records, and then that serves as a lien against any property owned by the judgment debtor. So, for example, a judgment debtor may own a home where that judgment debtor lives in Harris County. An abstract of judgment then gets filed, and it purports to encumber the home of the debtor in Harris County. Except Texas has a law that says, and it arises out of the Constitution, it's also codified in the property code. Texas has a law that says those types of liens, judgment liens, don't attach to the homestead. So when a person who has a judgment wants to sell their home, which is their homestead property, the title company will say, well, wait a minute, we can't insure title. You can't sell this property because you've got an abstract of judgment lien. And the title company will say, okay, go talk to a real estate lawyer. So then the judgment debtor will then call us and say, Mr. Real Estate Lawyer, what do I do? And we'll say, aha, we're happy to help. We can have that lien released according to a process in the property code, and then you can return to your transaction and sell your homestead property free of the judgment lien. So that's what we're talking about today. So we're going to go through this process as outlined in the Texas Property Code. It's 52.0012, release of a record of lien on a homestead property. So let's just kind of dig through this code section. Like all statutes, we start off with the definition section. So homestead has a certain meaning. Don't worry about that too much. When we're talking about homestead, we're talking about the judgment debtor's place, usually where they live, but they don't actually even have to live there. It just has to, in Texas, that's a place where they've intended to be their homestead, and they don't own any other property that's their homestead. You only get one homestead in Texas. All right, judgment debtor and judgment creditor have the meanings assigned by these code sections. Don't worry about that too much. A judgment debtor, for our purposes, is someone who got a judgment against them, and a judgment creditor is someone who benefits from that judgment as ordered by the court. And then it says in B, the judgment debtor may file in the real property records, that those are records kept by the county clerk throughout the various counties in Texas, can file an affidavit that substantially complies with subsection F. We're going to get to F in a second. That F is the section that says here's what your affidavit looks like. But the judgment debtor is going to file this affidavit, and it's also going to file a proof of mailing. That's two, a certificate of mailing that complies with subsection G. So two things that's going to be filed in the real property records by the judgment debtor to get the lien released against the homestead is going to be an affidavit that complies with F, and then a proof of mailing. So moving right along, the judgment debtor files an affidavit. You have to send a letter notifying the judgment creditor of the filing of the affidavit by certified mail, return receipt requested to. So the judgment debtor is going to file this affidavit that they've filed in the real property record, certified mail, return receipt to, here's one, the judgment creditor's last known address, pretty simple. Two, the address appearing in the judgment creditor's pleadings. So if you think about the underlying court action where the judgment debtor lost and got this judgment against them, in the pleadings, like the petition of the judgment creditor, when you start a lawsuit in Texas, you do that with a petition, and in that pleading, there's going to be a signature block, usually signed by an attorney, and it could have, it's going to have that attorney's address, but then it will also, the petition will also have a party section usually, and the judgment creditor's address will be in the party section of that petition. And then the last known address, if that's different than another last known address. So you're sending it to the judgment creditor, last known address, that may be the same or different in the judgment creditor's petition. And then you've got to send it to the judgment creditor's last known attorney as well. That's shown in those pleadings in the court record. So you're going to have to go and pull that underlying lawsuit to get that information. And then you also get you can also look up the attorney's information on the State Bar of Texas website if that address is different than what's in the pleading. So you've got different places that you could be sending that copy of that affidavit to, but that's a big part of getting this the judgment lien released, because you've got to file the affidavit and you have to file proof of mailing to all the correct parties. So once you do this, except for these other things that we'll get to, once you file the affidavit, it's going to serve as a release, as a conclusive release of the judgment lien against the homestead property. So you file the affidavit, you file the certificate of mailing, and then as long as there's no contradicting affidavit filed under subsection E, because what's going to happen is the judgment creditor is going to get an opportunity. They almost never do, but the judgment creditor is going to get an opportunity to file a contradicting affidavit saying, oh, no, that's not true. That's really not their homestead, or this is untrue. But that, again, they almost never do that. So if a judgment debtor has filed the certificate of mailing, that's the certified mail return receipt notice to the judgment creditor and the judgment creditor's attorney, and there's been no contradicting affidavits filed, then it goes on to say a bona fide purchaser, mortgage, That's a bunch of legalese for basically saying the title company is going to do insurance. Okay, so if you've done those things, the title company will issue insurance and you'll be able to close their deal. This provision in the property code is giving the title company some comfort that they're able to insure this deal, and the judgment debtor has gone through the proper steps of this process for having it released. So, and then you get into E. This is the part where if the judgment creditor files a contradicting affidavit saying 1 and 2, which is it's untrue. Okay, that affidavit the judgment debtor filed is untrue, or another reason, then if as long as the judgment creditor doesn't file those things, then the title company is going to be able to insure your deal and get it closed. And again, that almost never happens. I think one time of the hundreds of these our firm has done, we've seen maybe 1,000. I don't know how many of them we've done, but a lot of them. As long as the judgment creditor doesn't file these things, the lien is going to be released under the statute. And then here, section F is the affidavit. Okay, this is what actually the judgment debtor is swearing to. And this is your attorney, or if a judgment debtor is trying to do this on their own, you're going to have this affidavit signed. And the affiant is going to say, before me, the debtor, the affiant is inserted here, sworn upon oath states that, we're the name of the affiant, we own the following described property. You put the legal description here of the homestead, and then it's the purpose of the affidavit is for effecting a release of the judgment lien recorded in, and then you put where it's recorded, and then the land includes the homestead as the homestead is defined in this property code section. And then you've got some exclusion language that says, okay, the land isn't included. This is the 10 acres, which is urban homestead, and 200 is rural homestead. This is saying your property, your homestead property, doesn't include any property that exceeds the limitations on homestead. And again, that's very rare. Most people don't own over 10 acres in the city, and most people don't own over 200 acres in the country. But if you do, then your homestead protection would not extend to that. But that's very rare. And then it just says the affidavit serves as a release of judgment lien to the land in accordance with this section, and it's signed by on a certain date. The affiant sign it there. Your notary block goes here. Note that this is a jurat as opposed to an acknowledgement. An acknowledgement is just where the notary says, "Hey, I saw the person sign it in front of me." A jurat, which is sworn and subscribed to, this is where the person is actually swearing under penalties of perjury that what they're testifying to is true. And then here's your form for your certificate of mailing. And this is what goes out to the last attorney of record. It goes out to the creditor's last known address. It's basically saying, okay, my name is the affiant, that's the judgment debtor. On this day, we recorded the judgment, the affidavit. On this day, we recorded the affidavit saying, hey, this is our homestead property. We sent a letter notifying the judgment creditors to all these places, and this also gets recorded in the real property records. The proof of mailing gets recorded and testified to. This is again a jurat, and then there's your form. So it gives you the form that's being recorded. Here's your affidavit that's going to be recorded, and then here's your certificate of mailing that's also going to be recorded in the real property records to affect the release of the judgment liens. A couple notes. This process became effective September 1st, 2007. So any abstracts of judgments recorded prior to September 1st, 2011, this doesn't actually apply. This process is not going to be available to judgment debtors that had really old abstracts of judgment. This process is only available to judgment debtors that had abstracts recorded in the real property record September 1st, 2007 or after. One other note, if you have a child support lien, there's a very similar process under the family code for releasing child support liens against the homestead. Very similar process to that. But hopefully this has been a good educational video for releasing judgment liens against homestead property. If you like this educational video, please remember to like and subscribe. Thank you for watching. Phil Silberman with the Silberman Law Firm signing off.